All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Madam Court Officer, you may call the case.
Good morning, Your Honors. This is case CPC 2020-06. The Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
We continue with the cross-examination of the witness. Madam Bashir, would you please escort the witness into the courtroom? Good morning, witness. Are you hearing okay?
Good morning.
We continue now with cross-examination. Mr. Roberts, who's standing to your right, representing the Salimi defense, will have the next cross-examination. Go ahead, Mr. Roberts.
Thank you, Your Honour. Good morning, witness.
Good morning.
Into private session, please.
Into private session, please, Madam Court Officer, for the protection of the witness.
Your Honours, we're in public session.
Witness, I want to ask you some questions about the history up to June 1998 of the use of masks by various, by the two principal protagonists to the conflict. First of all, you said that Serbian police officers would wear masks when carrying out certain duties in Kosovo. Is that right?
Yes.
Obviously, a practice that had been going on for some time. Is that right?
Yes, it continues to this day. There are special units within police forces of various countries who wear masks during various actions they undertake.
I understand that. But in relation to Serbian police officers in Kosovo, was there a perception that police officers would wear masks on operations that often led to allegations of ill treatment and torture by Serbian police?
Dear Council, dear panel, we have had an awful experience at the hands of Serbia. This is not confined to the use of masks. They trade in human cadavers, in human bodies. It has killed and massacred. There are 15 or 16 places in Serbia with bodies of Kosovars.
Mr. Emerson gives you. I understand that you have.
Thank you, thank you.
Please just answer the questions.
Thank you, by all means.
Let me ask the question very simply.
And that was the reason. It was confined to identification issues because Serbs could use anything and do anything, and the blame would be shifted onto the Albanians. That was the only reason.
And when the Kosovo Liberation Army very first made a public appearance, I'm going to suggest to you, it was on the 28th of November 1997 at a funeral in Lauscha of a teacher who had been, it was thought, murdered by Serbian police officers. Is that right?
Yes.
KLA appeared at all in public as the members of the KLA, and there were three people there, three KLA members who gave a three-gun salute to the dead teacher, and they were wearing masks at the time of the salute. Is that right?
Yes.
An illegal organisation announcing its existence in front of the media, everybody understood the need for them to wear masks, didn't they?
Yes.
And in the early days, between that occasion, the 28th of November 1997, and let us say April, May, let's say June of 1998, so between the end of 97 and June of 1998, the early part of 1998, when attacks were being mounted by the KLA, for example, as they often were on Serbian police outposts or on isolated military operations inside Kosovo, typically in or around police stations, the members of the KLA who would be mounting these clandestine operations would wear masks, wouldn't they? That was what was known and believed. Is that right? At that stage, before the war was fully underway.
Yes, it would have been usual and necessary for them. I did not wear one.
We're talking before before the June period. We're talking up to that point, from the end of '97, when specific military attacks were being launched, and what was described by one expert witness as shoot and scoot type of attacks. Masks were worn to conceal the identity of the people responsible on the KLA side for those attacks. Is that right?
Objection, Your Honor. We're now going far beyond the scope of Judge Barta's questions. The fact Judge Barta asked a question about masks doesn't give counsel carte blanche at this stage of the examination.
I will say that the questions about masks had to do with his zone far after the period you're talking about. So I think you should confine it to that.
Yes, I was just trying to, because I think Judge Barta's questions were
I think we've heard enough history. I think we know there's some history for it.
But once, the proposition I was essentially moving towards was that whilst masks were common in the early period, from June onwards, it wasn't policy for people to wear masks any longer because there was a fully fledged war ongoing, and the risk of reprisals from the Serbs on individuals wasn't there in the same way. Is that right?
Objection, Your Honor. It's a broad question. Could the witness be asked within his sphere of knowledge, or could it be specified where he's being asked about the use of masks or not?
Yes,
Look,
I will confine
it's a
it.
fair question.
Within your sphere of knowledge, did the use of masks by the KLA become much less common from June onwards?
Yes, it did. Even though this depended on every zone and territory, I am not in a position to evaluate their assessment. They each and every one of them made their own assessments in their own zones.
Within the area where you were during the period mid-98 till the end of the war, bearing in mind the evidence that you've already given, did you in fact encounter and have to attack members of the KLA that entered your area wearing masks at any time?
No, there hasn't been a single case.
Thank you.
Your Honor, I spoke too quickly. I just have a very brief two questions to ask this individual. Very briefly, I apologize.
Go ahead.
Witness, you noted in response to a question by Judge Bartha that the worst thing that anybody could say about you would be to describe you as a collaborator. Isn't that right? You find that humiliating. Is that correct?
We considered that as degrading, humiliating, and so on. That does not apply to me alone. It applies to the entire population.
individual had a score to settle or had some revenge with somebody else in the village, the way to humiliate that person would be to describe that person as a collaborator. Isn't that right?
If you want to be utterly humiliating, you call someone a collaborator.
Thank you for your indulgence, Your Honor.
Yes, Your Honor. I have, I think, 3 questions.
Okay, we're now into the break time, and I really would like to get to this other witness that we have to see. If these are these all connected to the questions that have been asked?
Yes.
Go ahead.
Thank you. Witness, you were asked a question by His Honour Judge Barter, which began, and the purpose of that meeting was to discuss a communiqué written or at least published by Mr. Krasniqi. And I wanted to ask you directly, witness, you cannot positively confirm who wrote or who published the document that we've been discussing, can you?
Objection, Your Honor, that doesn't arise from the judge's questions. The issue of authorship and the purpose of the meeting has been canvassed in the admitted statements, in my direct examination and in cross-examination. This is unnecessary and should not be allowed.
Witness, would you like me to repeat the question, or did you understand it?
No, I understood it. At the time this was drafted, I thought this was drafted in relation to me and the KLA spokesperson, Mr. Krasniqi. At the time when I saw the communique, I realized it did not mention the name of Krasniqi, but it referred to the institution and it did not contain my name.
Yes, thank you, Your Honour.
Your Honour, I do apologise, and I appreciate the time issue, but I have one matter that I do need to raise. Which
If you can make a short question, not a 20-minute question.
No, it'll be a very short question. Both Judge Barter and Judge Metro asked you about, A, whether you had yourself at the time conducted investigations into the abduction of Jakub Krasniqi and Chen Deku, and they asked you, and you said no, and they asked you whether it had come up in your conversations after the war. Can you please, and you said no again, could you please explain why you didn't conduct an investigation at that time in the light of what was going on in your area, and why this never came up in conversation after the war?
First of all, this did not happen in my zone. It is in the municipality of Malisheva. And secondly, I did not have the authority to investigate.
That's helpful. And when you did you see either of them again during the war or only after the war?
No, I only met them after the war.
How long had elapsed between the time of their disappearance and the time you next met them? How long a period after the war was it that you met with them?
I wouldn't know exactly, but I know that it was immediately after the war, those moments after the war.
That a great deal had happened in that intervening period to you and to them, given the ultimate outcome of the conflict. Why was that question of that period when they were in KLA custody not the top of your agenda when you met with them to discuss the war?
I object as to relevance and, again, not arising directly from the scope of the judge's question.
He's already answered it anyway.
Well, I don't think he's given the reason.
He said it wasn't in his zone?
No, that was to do with the investigation during the war.
You are now on your 5th question.
Well,
you told me you...
why was that topic of what had happened to them previously not at the top of the questions or conversation that took place when you met them after the war? Both of the judges were interested to know what the reason was, and I don't think you gave the reason why. You didn't discuss that with them after the war. Can you help us with that?
This was my decision because I did not want to hurt them.
Mr.
Again,
Emerson, we're finished.
I'm not going to ask a further
We're
question
finished.
if you think that answer is clear enough.
We will take a break. No, we won't take a break. We're finished with you, sir. I'm sure you're glad to hear that as well.
Thank you very much.
With us and sharing your information with us, and thank you for the time you spent. You are excused now, and Usher will escort you out of the room.
Thank you very much.
Vicky. Told the witness from yesterday is or will be ready on time. We'll take a 30-minute break and then we'll be ready for him. Thank you very much.
All rise.
We're adjourned.
All rise.
Be seated. So we will now continue with the testimony of W03827. Court officer, please allow the witness to join us via video conference. Hello, witness, can you hear me?
Yes, I can.
Continue with some questions for you. Mr. Misitich, representing the Thaçi defense, will be asking some questions at this time. I want to remind you, you are under an obligation to tell the truth as set out in your statement yesterday. Do you understand that?
I do.
Misitich.
Thank you, Mr. President. Good morning, witness. Mr. President, I believe we should go into private session.
Good morning.
Madam Court Officer, into private session, please. Private session or public?
It will be a motion for reconsideration of the panel's decision to admit this witness's statement. I don't know, I think it's probably best to do it in private session, but
All right, we'll stay in private session then.
may I have leave?
Yes.
Thank you. Mr. President, members of the panel, the Thaçi defense moves pursuant to Rule 79 for reconsideration of the panel's decision admitting the statement of witness W03827 based on two grounds. First, because there has been a clear error of reasoning, and second, because it is necessary in order to avoid injustice. New facts obtained after the trial panel rendered its decision justify this request for reconsideration. Specifically, the trial panel has now had an opportunity to confirm that the accused have been denied an adequate and proper opportunity to cross-examine witness W03827, and this requires the trial panel to reconsider its earlier decision admitting his statement. On the first ground, with respect to the error in legal reasoning, the trial panel erred when it admitted the statement of this witness pursuant to Rule 143, Subpart 2, Subpart C, without having seen whether the accused would be able to adequately and properly cross-examine the witness. We have already cited to you the judgment of the Constitutional Court of the Kosovo Specialist Chambers. That citation again is KSC CC PR 2020-09, Judgment on the Referral of Amendments to the Rules of Procedure and Evidence, adopted by the plenary on 29 and 30 April 2020, issued on 22 May 2020 at paragraphs 76 to 81. In paragraph 79 of that judgment, it is stated that the accused must have a, quote, adequate and proper opportunity to cross-examine the witness either when the prior statement was made or during trial. The Constitutional Court twice noted that the opportunity to cross-examine must be both an adequate and proper opportunity to cross-examine the witness, and that is at paragraphs 78 and 79 of the judgment. We also wish to bring an additional authority to the attention of the trial panel. I don't know if we have it in the queue. We sent an email earlier, but it is the judgment of the appeals chamber of the ICC in the case of the prosecutor versus William Ruto and Joshua Arap Sang, dated 12 February 2016, and we have it as DHT 01971 to DHT 02007. Can we call it up? And if we could go to page DHT 02005 at paragraph 93 of the appeals chamber judgment. This judgment, members of the panel, dealt exactly with the issue that's before you today, the admission by the trial panel of the ICC of a prior statement for the truth of the matter asserted where the witness recanted his testimony in the prosecution's examination in chief. There, the ICC appeals chamber held that it considers that the prior recorded testimony was admitted without any proper opportunity for the accused to cross-examine the witnesses. The appeals chamber notes that the witnesses whose prior recorded testimony was admitted pursuant to Rule 68, Subpart 2, Subpart D of the rules, testified in court. However, in doing so, they recanted the content of their prior recorded testimony. The appeals chamber considers that where such recantation occurs, it cannot be expected that the accused would proceed by eliciting incriminating evidence from the witness in order to be able subsequently to challenge that evidence. This is the case regardless of whether or not they are on notice of a potential application by the prosecutor under amended Rule 68 of the rules. The appeals chamber therefore considers that even if the accused had an opportunity to question the witnesses because they appeared before the court, in the absence of the prosecutor eliciting incriminating evidence from the witness in examination in chief, such questioning does not amount to a meaningful cross-examination. It follows that the evidence was admitted for the truth of its contents in circumstances in which those witnesses denied the allegations made in that evidence, and meaningful cross-examination was not possible. The appeals chamber then struck down the offending decision of the trial panel. We submit that we have that exact situation before you now. The ICC appeals chamber decision reflects common sense. I quote, "Where such recantation occurs, it cannot be expected that the accused would proceed by eliciting incriminating evidence from the witness in order to be able to subsequently challenge that evidence. And also, even if the accused had an opportunity to question the witnesses because they appeared before the court, in the absence of the prosecutor eliciting incriminating evidence from the witness in examination in chief, such questioning does not amount to meaningful cross-examination." In the case before you, the prosecution did not elicit any incriminating evidence in its examination in chief. The trial panel cannot expect that the accused would try to elicit in cross-examination the incriminating information contained in the witness's statement so that the accused could then try to cross-examine him on that information. The way the questioning unfolded on cross-examination does not amount to meaningful cross-examination, as the ICC appeals chamber confirms. You heard the witness repeatedly say he does not recall anything, and with respect to specific allegations, at certain points, and I can cite the transcript to you, he explicitly recanted by saying, "I did not say that." When I put to him, "Did you say that Hashim Thaçi, Recep Salimi, Sabit Getzi ordered the crimes committed?" The trial panel may have also noted in my questioning that many of my questions, but not all, that I put to the witness in cross-examination were almost verbatim repeats of the questions that were put to him by the prosecutor in direct examination. We did that quite intentionally because the prosecution took the position that the witness's answers to those questions were intentionally evasive. The prosecution's position essentially was that the witness's evasive answers denied the prosecution the ability to elicit his viva voce testimony on direct examination, and therefore the panel should admit his prior statement into evidence for the truth of the matters asserted. It is self-evident that when the witness gives the same answers to the exact same questions, this time posed by the defense in cross-examination, those answers cannot amount to adequate, proper, or meaningful cross-examination. Because the accused has been denied an opportunity for an adequate and proper cross-examination, the statement of this witness is inadmissible under Rule 143, Subpart 2, and under the holding of the Constitutional Court. The trial panel committed a clear error of legal reasoning in admitting the statement. Reconsideration is also necessary to avoid injustice. The Constitutional Court held in paragraph 77 of its judgment that what is at stake here is nothing less than, quote, "the right of a person charged with a criminal offense to examine witnesses against him or her under Article 31, Subpart 4 of the Constitution and Article 6, Subpart 3, Subpart D of the European Convention." This right is a specific aspect of the right to a fair trial set forth in Article 31, Subpart 2 of the Constitution and Article 6.1 of the Convention, which must be taken into account in any assessment of the fairness of proceedings, close quote.
Interpreters kindly ask the speaker to slow down when reading. Thank you very much.
Accordingly, if the panel does not overturn this decision, it will result in injustice through the violation of the fundamental fair trial rights of the accused by admitting incriminating evidence against him without giving him an adequate and proper opportunity to cross-examine that evidence. Moreover, this decision, if it stands, will serve as precedent for the remainder of this trial, pursuant to which the prosecution may again seek to admit witness statements through 143 Subpart 2 without the accused having an opportunity to adequately and properly cross-examine the witnesses who made those statements. It is therefore entirely possible that by the time the evidence closes in this trial, you will have several such witness statements in evidence, which you will have to incorporate into your final judgment, and which will therefore threaten to taint your entire final judgment because it will rest in part on an injustice to the accused through the denial of his fundamental fair trial rights. We therefore respectfully ask you to reconsider your decision admitting the statement into evidence pursuant to Rule 143, Subpart 2, and instead to exclude the statement from evidence. By doing so, the panel will align itself with the judgment of the Constitutional Court, as well as the jurisprudence of both the ICC Appeals Chamber and the European Court of Human Rights. Reconsideration is necessary in order to correct a clear legal error, to avoid injustice, and to ensure that the panel's final judgment in this case is not tainted by this error. Thank you, Mr. President.
Thank you, Mr. Misitich.
May I just briefly clarify the position of the Vasili defence? We entirely support the submission that has just been made. The witnesses' statements do not contain any evidence relevant to our client, Mr. Vasili, and we had not been intending to cross-examine, which is why we didn't join the motion in relation to the video link, because it seemed unreasonable for us to be requiring the attendance of a witness we had no questions for. But this is a very different situation, because this is a ruling of law. It is manifestly the wrong route by which the matter should have been considered. It will, of course, taint the entire proceedings for the reasons that Mr. Misitich has outlined, and it could happen again. And it's we all make mistakes. The difficulty and the challenge is facing up to them when they've been made or decisions have been made too quickly. That we would respectfully submit is the position here, and it must be corrected at this stage. Otherwise, the spectre arises of this judgment, this case continuing for a very long time, and then any resulting conviction of any of the accused being overturned on appeal and a retrial ordered. Simply in the interests of justice and expeditious decision-making, this is the time to face up to the error and to put it right, to avoid what will inevitably otherwise in the submission of the defence be a procedural flaw in the trial, and as Mr. Misitich says, may well set a precedent which in other witnesses' cases could affect my client, albeit that this witness in substance does not.
Thank you, Mr. Emerson. Mr. Tully?
We join the motion by Mr. Misitich. I don't have anything substantial to add, simply to point out, it might be obvious to your honours, but for the record, the questions that I asked, and I believe Mr. Misitich asked, were predicate questions upon which cross would follow if the witness had indeed given us answers in order to be able to do that, but they were specifically and manifestly frustrated by the answers we were given. So to make it clear that this is not simply a question of whether meaningful cross-examination occurred, but it was attempted by the defence, and that did not happen based on the answers we were given. Thank you, Your Honours.
Thank you, Mr. Tully. Mr. Ellis?
Your Honour, we too strongly support the application for the legal reasons advanced, in particular that no adequate and proper opportunity for cross-examination was presented. We are in essence in the same position as outlined by Mr. Emerson. We weren't more vociferous earlier because it's not evidence that directly affected us, but we strongly support the legal principles enunciated.
Thank you, Mr. Ellis. Prosecution?
Yes, Your Honor. First and foremost, primarily, this is not the appropriate way to handle this application. The panel, in announcing its decision on Monday, indicated that it was a decision and that it intended to follow it with a written decision. And therefore, procedurally, this is premature. There is no rationale or reasoning. I understand that my colleague across the aisle, Mr. Misitich, has characterized the SPO's argument in a particular way, as well as the panel's reasoning in a particular way. But we haven't actually received a detailed reasoning from the panel. And so the appropriate time to do this would be after receiving that written decision and then making written filings on this. Briefly, though, on the ICC decision, we've just seen it while we were sitting here in court. I completely understand, and that's not a critique, but I'm not prepared to fully speak to it. That said, just from a quick review, it appears that it was a decision based on the ICC's analogous rule to our Rule 155, not 143. And I believe there are some other distinguishing factors, but I'd like to wait so I can read the whole thing before making a submission. And just finally, in the Supreme Constitutional Court's judgment when it was reviewing the amendments, including the amendment to Rule 143, it ultimately found that that rule was consistent, understanding exactly its application, that it authorizes the admission of a prior inconsistent statement for the truth of the matter. And the cases that are cited within, including other European Court of Human Rights cases, support the case that we cite yesterday, Vigdin, as well as the brief arguments that we made yesterday. So with that, I have nothing more to say at this point. We will wait for this panel's ruling, and then we look forward to responding to the written submissions, unless these oral submissions are the defense's entire submissions, and then we'll respond to those in writing with the permission of the court.
Mr. President, I'll be very brief. I appreciate the prosecutor's comments. I will just say that in terms of the timing, it was an oral motion by the prosecution, an oral decision by the panel, and we do feel an obligation, even before you issue your written decision, to bring arguments to you, including legal authorities that you may want to review before either making a final decision or reviewing our motion for reconsideration or filing a written opinion. So that's why it was brought to your attention immediately. However, the court wishes to proceed. Obviously, we will abide by that, but we stand by our application that this should be reconsidered.
First of all, we will file our decision,
What did I say?
and then we will go from there. All right?
Okay, very good. Thank you.
I believe you're correct, though. I don't believe you're correct. You are correct. It was an oral motion for admission, and we did admit it and said we would follow it up with our written decision with our reasoning. That's still going to happen. Judge Gaynor?
Yeah, thank you very much, Judge Smith. Question is about the Ruto decision from the ICC Appeals Chamber. And my question would be this. The issue was whether a rule not in existence at the beginning of trial could be applied during the trial. So the newly amended rule at issue could only be applied in accordance with Article 51(4) of the ICC statute if there was no, it could only be applied retroactively if there was no detriment to the accused. So the issue before the appeals chamber was, is there detriment to the accused? And they found that there was. So here the ruling question existed at the start of this trial. So does that change your submissions in any way?
It doesn't, because whether the rule was in existence or not in the Ruto judgment, the principle with respect to having a fair and proper opportunity to cross-examine remains the same. So even under the new rule, there must be a adequate and proper opportunity to cross-examine, at least as held by the appeals chamber, as held by the European Court of Human Rights, and I believe as held by the Constitutional Court in this court. And I would also say that regardless of the timing of the rule in Ruto, the Constitutional Court here authorized the rule, but with expressly referencing the fact that there has to be an adequate and proper opportunity to conduct cross-examination in order for something to be admissible under 143(2). And that hasn't happened here, and the Ruto opinion expressly deals with what is or isn't a fair and proper opportunity to cross-examine. And I think clearly on the four corners of paragraph 93, it's the same what happened here. We did not get just because he showed up and answered questions by saying, I don't remember anything, I don't remember any of these people, that's not a fair and proper opportunity for cross-examination. And I would also, let me just finish by saying, that's precisely why I repeated the questions of the prosecution. So it cannot be the case that the unfairness to the prosecution in the witness's answers to those questions results in a prior inconsistent statement coming in for the truth of the matter asserted, but when the defense asks those same questions and gets the same answers in cross, that's a fair and proper opportunity for cross-examination.
Let me ask you if you could develop your argument on a slightly separate issue. In Ruto, the appeals chamber of the ICC said that the witnesses in question recanted the content of their prior recorded testimony. Now, on the basis of the answers that this witness has given, is it your position that the witness recanted the content of his prior testimony?
So I would say that coming in and saying he does not recall is tantamount to recanting, because it essentially denies the accused the opportunity to challenge the evidence. And I think you need to read that recanting in the context of the later sentence in that ruling, which says that what is key is that the prosecutor elicit that incriminating evidence from the witness in examination in chief so that the accused can confront it. But let me also draw your attention to this witness's express recanting of testimony, and I can do that. And this is at transcript page 7692, line 11 to 7693, line 8. Question by the prosecution. So do you remember telling them that the people who ordered the beating were Hashim Thaçi, Recep Salimi, and Sabit Getzi? Witness's answer, no, I did not say that, and neither do I recall it. Question. So I just want to understand your answer. You're saying that you recall that you didn't say it, or you don't recall saying it? I said I do not recall having said it, which means I did not say it. So,
could I ask you just another question on the same subject? Rule 1432 of the Rules and Procedure and Evidence of this court refers to a scenario where the witness may reasonably be supposed to have knowledge, and about which it appears to the panel that, when questioned by a party, the witness is not making a genuine attempt to give evidence. Those are the words used in the rule here. Would you accept that that describes quite accurately what we saw when this witness was questioned both by you and by the prosecution?
if I may just have a moment to pull the rule up. Yes, I just have to scroll.
The interpreters kindly ask the speakers to slow down a bit and pause between question and answer for the purposes of interpretation. Thank you.
The reason I wanted to make sure on this point is that rule, now that's an invocation of 143 subpart 2 subpart B. That provision does not, it is not related to a prior inconsistent statement. So as I read that rule, it says that you may question a witness about a matter which is, he's supposed to have knowledge and he's not making a genuine attempt. But then C is the invocation or use of a prior inconsistent statement. And so the admission of the statement has to be under 143 subpart 2 subpart C. I do agree that as a factual matter, he appears to have knowledge of the matters in his witness statement. He does not appear, based on the information we were provided, to have a medical reason why he would suddenly not be able to remember anything. And the second part of your question was, he's not making a genuine attempt. Yes, I would agree that he was not making a genuine attempt to answer our questions. So, but it then has to fall under subpart C in terms of use of a prior inconsistent statement for admission. And I would again fall back on what is the distinction in admissibility between 143 subpart 2 subpart C and 155 subpart 2. The distinction is precisely in the ability to cross-examine.
And I'm glad you brought that up, because that was exactly where I was going. I alluded to this 2 days ago on the same question. If a statement is admitted under 155,
yes,
or it's admitted under Rule 143, you are, I think you agreed, are in precisely the same position in terms of your ability to cross-examine the witness.
That is correct.
So why is it that you would prefer to go down the Rule 155 route? Is it because the preconditions are stricter?
Absolutely. So this is what I was perhaps inarticulately trying to explain, I believe Monday it was. So there's a reason I could flip that question on you, say, why is the prosecutor moving under 143 subpart 2 and not under Rule 155? And I think the self-evident answer is because they don't believe they can satisfy the conditions of 155, which is now we're going to They're trying to open a new door through the misapplication of this rule. The distinction, I would say, is that first, 155 has passed constitutionality by the Constitutional Court without cross-examination. Now, it puts us in the same position, but I would argue that the conditions there were relatively strict in when that could be used, including that there has to be some evidence of interference, right? And in that situation, then the rights of the accused to cross-examination are being balanced against a competing interest of interference with witnesses and denial of evidence to the prosecution to be able to submit it. 143, there is no showing of some competing interest that would override the rights of the accused to confront and cross-examine under the European Convention and under the Constitution. So I guess my answer is that 155 was narrowly tailored to limit the rights of the accused to cross-examination in very specific circumstances, and this is why we're on our feet, is to say, in those circumstances, if the criteria are satisfied, then the statement can come in even without cross-examination. But absent that, you can't just stick in a prior inconsistent statement for the truth because a witness is being obstructive to both the prosecution and the defense.
Okay, let's be clear. The right of the accused to cross-examine is not limited under either 143 or 155. The panel certainly here has given you the opportunity to cross-examine. So the error is not the panel's, is it? You're not arguing that the panel has restricted your right to cross-examine.
The Constitutional Court has held, and this is why the Ruto decision is so important, it's not just that you can ask questions because the witness appeared in court. There has to be a meaningful cross-examination in order for it to be admissible. So what we believe the error was under 143 to admit the statement without having seen whether the defense will be able to have a meaningful cross-examination of the witness was error. We believe 143 should be applied going forward in the manner that the witness, if there's a situation similarly that arises in the future, the panel MFIs the witness statement, sees what transpires on cross-examination, and then there can be a discussion about whether the defense objects. If the defense objects, if the prosecutor wishes to persist to move it under 143 as opposed to 155, they can do that, and ultimately the panel can rule.
One final question. I think you said 2 days ago that 155 is the lex specialis for this kind of situation.
Yes.
What would you say to the observation that there appears to be two provisions in the rules which are essentially both lex specialis? And is there a reason, one provision being Rule 143.2 and the other provision being Rule 155.2? Why is the panel compelled to choose one lex specialis over the other? Aren't both available?
Well, as I said, there's a couple of distinctions. One, 143.2 requires a fair and proper opportunity to have a meaningful cross-examination. 155, for example, 155 subpart 1, and I discussed this with Judge Mitro on Monday, if there's a mental impairment that can be established with a witness that denies the accused an effective opportunity to cross-examine a witness who may have made a statement 15 years ago, but because of dementia, Alzheimer's, or something like that, cannot answer questions, the statement would come in under 155.1, and then you as the panel would have to give it the appropriate weight, taking into consideration that there was no cross-examination of the witness. But you couldn't get that same statement in under 143, right? Because there has been no fair and proper opportunity to cross-examine the witness. They would have to go under 155 if there was an impairment. We think the similar situation under 155 subpart 2. In terms of the application of 143, I think our experience has been that the use of a prior inconsistent statement under 143, where a witness is giving a statement on direct that's inconsistent, the statement can be used, but our understanding of the rule would have been that on a question-by-question basis, you can use the statement and say, you said this now, do you recall you said 5 years ago in an SPO interview this? And you can put that to them with leave of the panel, and then that can become used for the truth of the matter asserted. It doesn't mean that it becomes a Trojan horse where you ask 3 questions that's inconsistent and then the entire statement comes in for matters that you've never questioned the witness about in examination in chief. That would be another distinction between 143 and 155, which is the whole statement comes in.
Thank you. Those are my questions. Thank you very much.
Thank you, Judge Smith. Mr. Micetic, while you're on your feet, I'd like to ask you a few questions. First, about your reliance on the Ruto case and its underlying basis, and then I'll come to what I understand you to be saying about the Constitutional Court decision and the European Court of Human Rights. Regarding the Ruto precedent, what would you say to the suggestion that there is a relevant or even perhaps important difference between our Rule 143.2c and Rule 68.2d of the ICC rule, which is the basis on which the Ruto decision is based, in the sense that our Rule 143.2c specifically provides for the admission of a statement for the truth of its content, whereas the provision at the ICC does not do so.
If I can just... So again, I perhaps was inarticulate with Judge Gaynor. Our interpretation of Rule 143, Subpart 2c, is not that you can admit an entire statement through unless you put every question you had in the statement to the witness and then it comes in. The language of the statement of the rule is that you can put a question to him whether the witness has at any time made a prior inconsistent statement, by which we think it doesn't mean witness statement, it means you answered a question in a different manner previously, and I can put that matter to you now. Any such prior inconsistent statement may be admissible for the purposes of assessing the credibility of the witness, as well as for the truth of its contents or for the purposes within the discretion of the panel. So, I was at the scene, a witness says, I was at the scene of the crime. In a witness statement, he comes to court and says, I wasn't there. Can you put that to the witness? Yes. Can that come in for the truth of the matter asserted, the prior statement? Yes. Does that mean that if the witness gave a 300-page statement on other matters, that all of it comes in? We would argue that it does not mean that.
Well, I think it was my question that was inarticulate, Mr. Micetic, not your response. My question was simply a comparison between the legal basis at the ICC on which the appeals chamber relied, Rule 68.2d, I think it is, which does not provide for the admission of a statement for the truth of its content, whereas our rule does. What I'm simply asking you is whether that makes a difference in terms of your reliance or the reliance we could place upon that decision, where the normative basis at the ICC does not appear to provide for such a scenario.
I would argue that what we're arguing about is what constitutes meaningful cross-examination.
I'll come to that in a second.
That's why we're citing Ruto.
We'll come to that in a second. I'm just for the time being interested in whether we can compare pear and apple.
And I'm arguing it's apple and apple, and that's what I'm trying to explain.
Would it make a difference? I'll come in a second to the question of the cross-examination.
If you're asking me if in one court there's a rule that allows admission of prior inconsistent statements and in another there isn't, then as a procedural matter, obviously that's different. But as a substantive matter, there is no difference. That's my position.
Okay, I tried.
Okay.
The second thing is really about the basis of the reasoning in Ruto, where a core aspect of the paragraph you read to us is the fact that the witness is, in this case, denied the allegations. I think that's the expression they use to say, well, in effect, there was a prior statement and in-court statement that rejected the version initially given. Are you saying that in factual terms we are in a similar scenario here?
As I answered to Judge Gaynor, first of all, he did recant, and the word is recant is what the holding of the judgment of the appeals chamber says. So there is a portion, and I read it to Judge Gaynor, where he recants the testimony that the people who ordered the beating were Hashim Thaçi, Recep Salimi, and Sabit Getzi. That's the first point. The second point is it does not matter as a matter in consideration of the right of cross-examination, because I think you have to read further in that paragraph, and it talks about the key is that it's illicit, the incriminating evidence is elicited by the prosecutor in examination in chief. Now, whether he claims he doesn't remember or he claims he never said it, the key part of making a cross-examination effective is that you elicit it in direct. Why? Because the absurdity of the situation we were put in now. The statement comes in, the witness either denies making the statement or denies any knowledge of having made the statement, right? Because he's testified he doesn't remember even making the statement, which is a recantation. But let's say they put the statement in, and now somehow procedurally this is his substantive direct evidence which he denies any knowledge of. So you put the defense in the position, as the appeals chamber says here, of saying, oh, no, witness, you said this. In other words, force the defense counsel to elicit the incriminating information, to convince the witness that he did say something incriminating, just so that we could then cross-examine him on the point. And I think that's the key part of the appeals chamber reasoning here. That's the absurdity that makes cross-examination ineffective.
And I promised I'd come to the cross-examination point. You've cited to the Constitutional Court's decision. There's three little words you haven't cited, which is as a rule, followed by a comma. And it proceeds to say that this possibility should normally account for a fair and effective opportunity to cross-examine. Now, my question to you is, are you reading the statement and the authorities cited by the Constitutional Court in this case and by the ECHR as an absolute? In other words, is your position that as a matter of constitutional law here and human rights law, that there can be no situation where a statement could be admitted in those circumstances without the possibility of cross-examination or without the possibility of effective cross-examination?
Obviously, I'm not saying that because we have rules that admit witness statements of deceased people, of other people, and so that's on its face not what I'm saying. But I would argue that beyond where you're reading, as a rule, there's a subsequent paragraph that then discusses the application of that principle in the context of Rule 143, Subpart 2C specifically. And there's a specific emphasis on the application of this rule and the requirement that there is an adequate and proper opportunity to challenge and question the witness, and the obligation of the trial panel that if it didn't happen at the time the statement was made, the accused must, as a general rule, be given such an opportunity at a later stage of the proceedings. This opportunity, the Chamber observes, is specifically provided for in Rule 143, Subpart 3. So whether in 155 you have the right to cross-examination, to cross-examine a witness who is incapacitated, for example, obviously there is no ECHR or other jurisprudence that says that statement can't come in. So no, that's not our position. But if you're going to apply this specific rule, we believe the Constitutional Court has said there must be a fair and adequate opportunity to cross-examine.
Thank you.
Yes, Mr. Emerson.
I'd like to address one issue which seems to touch on a number of the questions asked by Judge Gaynor and Judge Metro, and indeed responds to the SPO. The search for what is the lex specialis as between these two provisions is obviously something which, as Mr. Misetic submits, the defence would say inevitably leads you to Rule 1552. But lex specialis is not the only principle in play where two competing provisions with different rules are said by the prosecutor or by indeed in discussion to apply to the same set of facts. The other is the fundamental principle that where two criminal law provisions apply to a situation, the provision most favourable to the accused must always prevail, sometimes described as lex mitior. So whether one looks through lex specialis or lex mitior, Lex mitia is, if you like, the most fundamental principle of criminal trial procedure, as well as of substantive criminal law that one can conceive of. And what we have here is a situation where the rule maker has decided that if a witness attends in court, and I think the exact words are, bear with me just one moment. As in 1552A, having attended, has not given evidence at all or in a material respect. Well, there's no question but that those words apply to this witness. And in those circumstances, the rule maker has decided that the prior statement of the witness may only be admitted if the cumulative requirement of 1552B, the failure to give evidence has been materially influenced by improper interference, including threats, intimidation, injury, bribery, or coercion, is also satisfied. Those are cumulative requirements. So what is for certain is that Rule 1552 provides a protection, a safeguard for the accused, which applies to this situation, without a doubt. In other words, that must be satisfied as a condition precedent. It is therefore not open to a trial panel to simply choose between the two provisions and decide which one will let the document in, because that is to deprive the accused of a protection that the rule maker, in this case that effectively the legislator, has said should apply in a situation such as this. Now, there could not be a clearer example of a situation in which, where two rules even arguably overlap. We suggest the lex specialis principle gives you enough guidance to say which is the appropriate one. But even if that were not the case, to adopt an interpretation which, with the purpose of depriving the accused of a protection that the law allows him, namely that that sort of witness is there and they refuse to give evidence in a material respect, then their statement can only go in if their refusal to testify in support of it is the result of intimidation or coercion. Now, that is the total answer to this situation, and without that being adequately addressed, I mean, unless the panel is going to find that the principle that the accused should not be deprived of a legal protection conferred by the legislature, and that the overlapping rules should be construed in the manner most favourable to the accused, principles which are very familiar, I think, to any experienced trial lawyer or judge as axiomatic principles for the conduct of a criminal trial. Unless the panel is going to say these principles don't apply, there really is no alternative to 1552. In a sense, I fail to see it really matters too much what the differences might be between the ICC provision or the wording of it or the precise facts of a particular case. You don't really need authority here. You've got two rules. If the defence are right, this lex specialis is clear. But even if we're wrong about that and there is an overlap between the two, the principle which should guide your decision is not one which, with greatest of respect and despite the eminence of the bench, it's open at this stage after so many hundreds of years to undermine, overturn, simply for the purpose of admitting a statement prejudicial to some of the accused in circumstances where the legislator has said specifically that must not happen unless it can be proved by the prosecution that the reason the witness isn't testifying is because they've been intimidated.
Thank you, Mr. Emerson. Mr. Tully.
Very briefly, Your Honour, just on a point that Mr. Emerson has raised regarding 1552B and the influence on the witness for improper interference with threats, intimidation, and so on. There were pointed questions asked by the prosecutor on Monday going to the fear of the witness had expressed in previous statements. I don't have the transcript reference, the official one, but the live transcript reference is on, one example is on page 95, beginning at line 24. And the question was, but you previously he had been interfered with in some way, in some improper manner, and that you can't trust his answer in court. So if there is a question that that pertains to Rule 1552B and whether it was satisfied, I believe that is what the prosecution was aiming for. I have nothing to add. Thank you, Your Honor.
Judge Barton.
Thank you, Judge Smith. I have one perhaps late follow-up question for Mr. Misetic to a question asked by my colleague, Judge Gaynor, namely, Mr. Misetic, if you agree that this witness has not made a genuine attempt to give evidence, why is the exclusion of this or of his prior statement the proper or maybe the only way or the only remedy and not, for example, an intervention by the panel to compel the witness to make a genuine effort?
I promise you that I was sitting in my chair regretting that I didn't address this question, so this is fantastic that you've asked me this question. I agree with you 100%. So the remedy we're seeking is not that the statement is permanently excluded. We just say that under this particular rule, this is not how it should proceed procedurally. It can be back in the prosecution's lap to take any of several measures. And this is where we were in a little bit of a difficult position on Monday, because why should we, as the defense, be moving to compel the witness to give answers? It's the prosecution's witness. They can seek a remedy from the panel, either in terms of finding him in contempt, compelling a medical examination, putting him in jail until he's willing to remember things, or they can proceed under Rule 155 and see if they've satisfied the criteria there. But our application does not say permanently exclude the statement. It's just that this is the wrong procedural framework that, again, threatens to taint the case, because if this is allowed, I dare say that it probably won't be the last application under 1432 to admit statements where the other party hasn't had an opportunity to cross-examine.
Thank you for making that clear.
Thank you very much. Thank you very much. We will break for lunch. Oh, I'm sorry. You.
I'll be extremely brief.
No, that's all right. I
right.
didn't mean to cut you off.
I appreciate both Mr. Misetic and Mr. Tully surmising what the prosecution was intending, but we would appreciate it if we are allowed to speak for ourselves. And that line of questioning in terms of concern or not wanting to be here did not actually talk about any specific evidence of intimidation. And that's clear from the transcript, so I'll let that speak for itself. In terms of what is apparent to this panel is that there is a difference, as articulated by my colleagues across the aisle, between 143 and 155, including the differences of element of improper interference, which is absolutely not included in 143. And so as the panel considers it, as it rightfully did, it considers that those would not be lex specialis over situations that don't have all of those same elements.
Just one second, if I could just respond to that. Because
well, then Mr. Emerson wants to respond also.
I'll only be one sentence as well.
Okay, one sentence each.
Okay. That submission, if that distinction between 155 requiring interference and 143 doesn't, I cannot imagine a scenario where if you admit this under 143, that the prosecutor will ever file an application under 155 subpart 2 to prove more things than they have to when they know that they can get everything in under 143. Basically, you're making 155 irrelevant. Thank you.
Well, I was going to put the same point, but in a rather different way. It's not about this prosecution's conduct or what may happen hereafter that may involve speculation. What is the point of the legislature including the 1552 route at all if the 143 route is satisfied on the facts of this case? And all judicial decisions on legislation have to proceed on the basis that you look at the rules as a whole. You seek to find a compatible construction. You can't simply read 143 in a manner that would render 155 completely otiose. And it would do, because there would be no circumstances, never mind what this prosecution might choose to do, there would be no circumstances falling in 155 that didn't also fall within 143, which lacks the protection. So with respect, whether you look at this on orthodox principles of interpretation or on the basis of the fundamental presumption of favourability to the accused, it doesn't really matter. You can't render that second provision and its additional safeguard OTOs. And any judgment that does that is inconsistent with the principle that the rules must be read as a whole.
Thank you.
I have one more question for you, Mr. Micetic. I'm sure you enjoyed the sound of that 2 minutes from lunch, but
I don't have to go to the gym because I've gone up and down so much.
I'm sure it's good for you.
Yeah.
I just want to be clear that your submissions is that the correct path procedurally in your understanding was paragraph 2 of Rule 155. You are not, in other words, relying on paragraph 1 of that provision. Do I have that right?
Let me just make sure. If you mean 1551, yes, I have not seen any evidence that he has an impairment, and I believe the parties are actually in agreement on that point. So, yes, that is correct.
Thank you.
Thank you.
All right, we will break until 2:30. We'll start with the next witness at that time. And we are in private session. We'll go to public session. Sooner or later, I'll get there, right?
Your Honours, we're in public session.
All right, we're adjourned till 2:30.
All rise. All rise.
Be seated.
Your Honour, I just have one very brief matter to raise just before the witness enters, if that's appropriate. It's very similar to submissions that have been made in relation to other witnesses of a similar type, in relation to the fact that obviously opinion evidence should not be elicited from that witness. But where it is, clear foundations must be established for such an opinion, and that an opinion of a witness should not go to any of the ultimate issues. Now, obviously, that seems to be a standing position of the Chamber, so it's not necessary, I would suggest, to issue the ruling. It's just obviously our position that this witness may enter into those areas. So just wish to raise it and place it on the record at present.
Thank you, Mr. Roberts. We will call in the witness now, Madam Usher. Witness W03724. I take it we will be in public session.
My apologies, Your Honor. Primarily, yes. However, as I've discussed with the defense inter partes, there are one or two matters that are confidential. The nature of the matter is confidential, so I will ask briefly to go into private session just to deal with those one or two things.
Okay. One other thing, Madam Prosecutor, following this witness tomorrow, is there another witness?
There is not. This is our last witness that we have ready for this week.
And estimates on time for you is short.
Less than 1 hour, including the 154. It might be closer to 30 to 40 minutes.
Any changes in your estimates at this point? Hard to say, I suppose.
As I indicated, Mr. President.
Yours is shorter, yeah.
Yes.
And we start with Mr. Roberts.
That's correct, yes, Your Honour. Mine is I think I'd estimated 2 hours. It's probably closer to an hour and a half, so slightly shorter.
We have no change to our estimate.
Okay, thank you. Mr. Ellis?
I think it is difficult to say at the moment. I'd have thought no more than an hour and a half. But
No problem. Witness, oops. Witness, I'll ask you to stand again, please, just for a moment. Stand. The usher is going to provide you with a text of the solemn declaration that we ask you to take pursuant to our rules. Please take a look at it and then read it aloud.
Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything which has come to my knowledge.
You can be seated now. Witness, today we will start your testimony, which is expected to last today and into tomorrow. As you may know, the prosecution will ask you questions first. Once they're finished, the defense has the right to ask you questions, and the members of the panel may have some questions for you as well. The prosecution's estimate for your examination is 1 hour. The defense estimates that it will take approximately 6 to 7 hours. As regards each estimate, we hope that the counsel will be judicious in the use of their time. The panel may allow redirect examination if conditions for it are met. Please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them you don't understand, and they will attempt to clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. In the event that you are asked by SBO to attest to some corrections made concerning your statements, you are reminded to confirm on the record that the written documents, that the written statement as corrected by the list of corrections accurately reflects your declaration. Please also speak into the microphone and wait 5 seconds before answering a question, and then speak at a slow pace for the interpreters to catch up with you. During the next days while you're giving evidence in this court, you are not allowed to discuss with anyone outside of this courtroom the content of your testimony. If any person asks you questions outside of the courtroom, please report it to us immediately. One final thing, please stop talking if I ask you to or if I raise my hand. That means there may be an additional instruction that I need to give you. If you feel the need to take breaks, let us know and we'll accommodate you. So we will begin here on your left with the SBO and proceed after that. Go ahead.
Thank you, Mr. President. Good afternoon, witness. We have met before, but I'll introduce myself again. I'm Deborah Mayer, and I'm a prosecutor with the SPO. Can you please tell us your name?
Robert McPhee Douglas Young.
And what do you go by?
Douglas or Doug.
What is your date and place of birth, Mr. Young?
Inverness, Scotland, 23rd October 1948.
And what is your nationality?
British.
Sir, did you give a statement to the SPO in May 2018 and October of 2019?
Yes, I did.
I'd ask the court officer to bring up 085942-085979 in English and 076162-076199-ATRED2 in Albanian. the first pages of both, please. Do you recognize this document as the record of your SPO interview?
Yes.
Can we please go to the last page of the English version? Is that your signature at the end there?
Yes.
Did you have a chance to review this document before you signed it?
Yes, I did.
And did you also have an opportunity to review this statement last week?
Yes.
Do you recall meeting with myself and my colleagues this past Sunday?
Yes, I do.
In that meeting, were you given an opportunity to provide clarifications in relation to this document?
Yes.
And did you, in fact, provide clarifications to this statement?
Yes, I did.
Do you recall these clarifications and corrections being included in a note which was read back to you?
Yes.
Subject to the corrections set out in the note, is the information provided in your SPO statement accurate and truthful to the best of your knowledge and belief?
Yes, it is.
And subject to the corrections set out in the note, does the information provided in your SPO statement accurately reflect what you would say if you were examined about the events recorded therein?
Yes.
Having addressed the Rule 154 criteria, we move for the admission of this witness's SPO statement along with the associated exhibits identified in F01625 Annex 4, which were provisionally admitted by the court in F01700, along with the preparation note. I will list each of the items by ERN for the court officer. The statement itself, as we have up on the screen in English, is 085942-085979. The Albanian version of that is 076162-076199-AT, RED2. The first associated exhibit is 067049-067049. The second associated exhibit, 050549-050549. The third associated exhibit, 067053 to 067055. The next, 050557-050557. The next, 067870-067896. The next is 067057-067066. The next is SPOE 000-59409-000-59410. The next is SPOE 00233-976-00233-979. The next is SPOE 0005-9421 to 0005-9423. The next is SPOE 0011-6964 0011-6973. The next has a lesser redacted version that's in the queue. In the motion, in the 154 motion and decision, it was SPOE 002-33678 to 002-33681. The lesser redacted version, which we are assuming that the court and the defense would want, is 003-4 840-003-40843. The next is SPOE 00116-952 to 001-16963. The next is also has a lesser redacted version that we just got authorization for, which is SPOE 002-33674 to 002-33677 was the one in the SPO's 154 motion and the court's decision, but the updated version, the lesser redacted version, is SPOE 0011-6760-0011-6763. The remaining associated exhibits are U007-9610 to U007-9621, Red 2. That is a multi-language document that has 2 English translations, because there are only a couple of pages that have English translations. Most of it's in English. The 2 English translation pages are U007-9616 to U007-9616-ET. And the second is U007-9618 to U007-9620-ET, Red 2. The last associated exhibit is 067045-067048, Red 2 in English. The Albanian version of that is 067045-067048-AT, Red 2. And finally, the preparation note that we're tendering is 115157-115161.
Any objection?
No objection.
No objection.
No, Your Honor.
Thank you. Those enumerated documents, plus the associated exhibits, are admitted and will be assigned a P number.
Thank you, Your Honors. The first one, 085942 to 085972, and the Albanian translation 076162 to 076199, AT revised, Red 2, will be Exhibit P 392. The second one, 067049 to 067049, will be Exhibit P 393. Third one, 050549 to 050549, is Exhibit P 394. 067053 to 067055 is Exhibit P 395. 050557 to 050557, Exhibit P 396. 067870 to 067896, Exhibit P 397. 067057 to 067066 will be Exhibit P 398. SPOE 0005940 to 000594010 will be Exhibit P 399. SPOE 002333976 to 002333979 will be Exhibit P 400. SPOE 0005941 to 0005943 will be Exhibit P 401. SPOE 00116964 to 00116973 will be Exhibit P 402. SPOE 0034084 to 0034084 will be Exhibit P 403. SPOE 00116952 to to 00116963 will be Exhibit B 404. SPOE 00116760 to 00116763 will be Exhibit B 405. U0079610 to U0079621 RED2, and the two identified translations will be Exhibit B 405, and the translations will be ET.1 and ET.2. 067045 to 067048 RED2 will be Exhibit B 406, and lastly the preparatory note 115157 to 115161 will be Exhibit B 407. Thank you, Your Honors.
I know that was a very long list. If I could just ask for a clarification from the court. I think I may have recorded that the SPOE 00116760 to 763 was 405, and that the one after that is also 405. I just want to make sure I've got the correct numbers when I use them.
Thank you. Yes, SPOE 00116760 will be P405. The U0079610 to U0079621 should be P406. And I apologize if I misspoke. 067045 to 067048 RED2 will be P407. And the preparatory note 115157 to 115161 will be P408. Thank you.
See, what was the last one? 400 and what?
408.
8, okay. Just for the record, P392 through 408, as now stated, are admitted.
Thank you, Your Honor. On 9 September, the SPO submitted a proposed summary of this witness's now admitted Rule 154 statement to the panel, defense, and victims' counsel. We have not received any objection to the proposed summary, and so with your leave of the panel, I would like to read the summary.
Go ahead.
Douglas Young served as a lieutenant colonel in the British Army Reserve and was deployed as a member of the UK Kosovo Diplomatic Observer Mission, KDOM, and then the OSCE's Kosovo Verification Mission, KVM, in 1998 and to 1999. Mr. Young left Kosovo in March 1999 when the NATO bombing campaign was due to begin, and returned to work for KFOR from October 2001 to April 2002. Mr. Young participated in establishing and running KVM Coordination Center 1, of which he was the deputy director, and which had responsibility over the Rehovich and Malasheva which had responsibility over Rehovich and Malasheva, and reported to Regional Center 1 based in Pristina. Through his work in Kosovo, Mr. Young engaged with the KLA regarding missing and abducted persons. Mr. Young engaged in meetings with the KLA in an effort to determine the whereabouts of individuals who are alleged to have been abducted by the KLA and to secure the release of such individuals. In one such instance, Mr. Young began trying to secure the release of the abducted person, Amer Jafici, on the day that he was detained by the KLA, and in that regard, had numerous interactions with KLA officials. Mr. Young, you've said that you served in the British Army Reserve, including several mobilizations and deployments in the 1990s in your SPO statement. Could you give the court a very brief overview of the military progression of your career?
Well, most of my service was at home in the reserves, part-time, and trained and worked in the United Kingdom and often in the British Army of the Rhine in Germany. I also had deployments to Norway and Cyprus. I was promoted to Major in 1980, having previously served as a infantry platoon commander, mortar platoon commander, and intelligence officer. I served with my infantry battalion until 1989, when I was transferred to a pool of watchkeepers and liaison officers and worked with the 2nd Infantry Division and then with the 1st Armoured Division, with whom I was deployed as a volunteer to the Gulf in 1990, serving through Operation Desert Storm in the desert with the Armoured Division headquarters. I returned to civilian life. My main profession was as a lawyer, working partly in private practice and for about 15 years in the public service and local government. I was then voluntarily mobilized again for Bosnia. In 1996, I was still a major. I served a tour as an operations staff officer as a major. At that point, I was put forward for promotion through the main British Army system, in other words, for substantive promotion, not acting. And I was asked to serve a further tour as the senior liaison officer from the British Division to the theatre headquarters in Sarajevo. So I was in Bosnia for a total of a year. Following the start of the Kosovo emergency, I was asked by the British Foreign and Commonwealth Office to be seconded initially to the UK KDOM, and then which would then transform into the OSCE KVM Kosovo Verification Mission. I served with them in Kosovo and in Macedonia. After returning home and continuing with civilian life, I was again mobilized to serve with KFOR, with whom my job was in helping to develop the Kosovo Protection Corps, which is mainly composed of veterans of the Kosovo Liberation Army. It was a very rewarding time, and I served with them for a further 6 months, which was really my last deployment in my Army service.
Thank you. As you've heard in court here, your SPO statement is now in evidence, so I'm not going to ask you to repeat everything that's in that statement. But in that statement, you discussed the process of how you performed your duties in CC1 Coordination Center 1, and that there were daily reports that were produced by CC1. I'd like to bring your attention to a particular one of those documents, and I'd ask the court to bring up SPOE 0011670, and ask you to take a look at that on the screen. So first at the top of the page there on page 1, the date on that is 26 January 1999. Were you still the Deputy Director of CC1 at KVM in Kosovo on 26 January 1999?
Yes, I should say that I only became the Deputy Director in the course of that tour. Previously, I was a patrol commander. And the comment in that document, headlined as Acting Director's Comment, I think...
if you just give me a minute to ask you the next question. I've just asked you about the date. So were you there on that date?
Yes, I was.
All right, if we can go to the bottom of page 2 of the document, and I'll ask you to look at the concluding block right above where the annexes are, and it lists your name with the title Acting CC1 Director. Can you explain that?
Yes. My job title at the time was Deputy Director, but the director, Georges Bordet, was temporarily ill with a serious local infection, and so he was basically out of the game at that point, and I, therefore, so that everyone understood my responsibilities, was designated as Acting CC1 Director.
And in this document, since it's under your name, did you draft or approve of the contents of this document?
Yes, I did.
All right, I'd like to bring your attention back to page 1 of the document. Under item number 2, at the very bottom of the page, the subparagraph 2 of item 2, which starts with reference to a CC1 two-vehicle patrol. And I'd like to direct your attention to the last 3 lines of that paragraph, the sentence that reads, "The KVM patrol was stopped by KLA, who claimed that they had not been warned by their higher formation about the patrol. Further details to follow. The same call signs are again deployed, parentheses, elsewhere this evening." I would like to ask you about that reference to higher formation. When you use that term, what were you referring to?
Higher formation is a very specific military term applying to the next higher headquarters in a chain of command. So the higher formation would be whatever was senior to the KLA unit which was encountered by that patrol.
All right, I'd offer SPOE 001-16730 through SPOE 00116733 into evidence.
No objection.
No objection.
SPOE 00116730 through 733 is admitted.
And Your Honor, that will be Exhibit B 409.
Thank you. You may continue, ma'am.
All right, I'd like to now show you on the screen SPOE 000-60949 to SPOE 000-60951 on the screen. Have you seen this document before?
Yes, it has been shown to me.
Was that during your preparation session on Sunday?
That's correct.
Do you recognize the type of document that this is?
Yes, I do.
And did you arrive in Kosovo for this deployment, the one that we're talking about between 1998 and 1999, in the month of November 1998?
Yes, I did.
And I'd like to draw your attention to page 2 of this document, paragraph, well, we'll start at the top of the page, and it's a Kosovo Verification Mission interim report, and it covers the period 24 November 1998 Were you familiar with these types of documents when you were deployed in Kosovo?
I don't think I would routinely require to see this sort of document, but I believe I did see them from time to time.
I understand. And to be clear, you did not author this document, is that right?
That's right.
I'd like to draw your attention to paragraph, or item number 2, rather, and the second paragraph under item 2. If you can look at that. And it refers to, in this report, what's being reported under developments in the mission area is that there was a meeting with a KLA commander, and KDOM was informed that that KLA commander had received a new directive from, quote, from the, quote, top of the KLA, end quote. And the directive was, it stated that the KLA has to help and support international organizations, not build barriers on main roads, and not to provoke the Serb police. Is that consistent with information that you learned when you were in Kosovo in 1998?
Yes, I do recall hearing that sort of detail, not necessarily in the same words, but that was what was happening at the time. We were deployed, certainly as far as the OSCE is concerned, initially to monitor the implementation of the Milosevic-Holbrooke Agreement. Therefore, nominally, we were responsible for monitoring the withdrawal of Serbian forces. But of course, increasingly, we were getting information about the KLA and communication from the KLA, and we also were able to observe the same effects actually on the ground. So yes, this is a sort of thing which I recall from that period.
I'd ask to bring up U002-2849 to U002-2851-ET, and the Albanian is the same ERN with no ET. And when that comes up, Mr. Young, I'm going to ask you to look on your screen at the first page, looking at the heading right there, as well as the first full paragraph, where it discusses or announces, although the Kosovo Liberation Army General Staff is not a signatory to any agreement, and I'm just going to skip down, that's the paragraph that I'm talking about. I'm going to start in the middle of the paragraph, where it talks about the KLA General Staff has long announced that it will offer assistance and cooperation to the stated mechanism, enabling it to freely carry out their own duties and obligations throughout the territory controlled by the KLA. They will not be blocked in their movements on the ground, and we guarantee them full security. Is that consistent with what we just discussed in the OSCE report in terms of what the conditions were, what was happening on the ground at that time?
Objection, Your Honor. As to how the question was formed, I'm not sure what's being asked, and also calls for speculation. There's no foundation for what the witness would know about this document. There's no foundation for the previous document either.
I believe I've established a foundation for the previous document if it was consistent with what this witness learned from his own work. And as to this, I haven't asked him. I've asked him if what's stated explicitly in the document is consistent with his experience on the ground in Kosovo, which I think is an appropriate question. I'm not. I'm just going to
offer it?
I'm not. I'm going to ask him if it's consistent with his experience.
Please look at your question again and re-ask it and perhaps refine it a bit.
I'll do my best.
I guess that's partially sustained.
Let me just ask explicitly, did you author this document, this KLA document, Mr. Young?
Did I author it?
Yes.
No.
And had you read this KLA document prior to being shown it on Sunday?
No, I don't believe so.
Okay, so understanding those caveats, that this isn't your document, you hadn't seen it before it was shown to you, is that sentence, that paragraph that you looked at and the sentence that I read to you about, again, just on its face, the KLA's position of how it's going to expect conditions on the ground to be, is that consistent with the actual conditions that you experienced on the ground?
It is in general consistent. However, as to the statement that they will not be blocked, we were blocked at times or in particular locations. I was once filmed by the BBC being blocked at a particular checkpoint, a KLA checkpoint, which I could not pass. And there was another location which was a permanent block. I, in fact, was able to negotiate to routinely pass it a short distance in order to refuel my vehicle, but most of our other patrols were not allowed, and that was the situation throughout the deployment. I'm sure there are other examples, but generally we were able to pass freely.
I understand, and going back to, if I can, ask the court to bring back up the previous document, which is SPOE 0006049 to SPOE 0006091 on page 2 again, that second paragraph under item number 2. While that's coming up, let me just ask you, that previous document that we were looking at, it said Kosovo Liberation Army General Staff on the top. Do you have an understanding of where the General Staff fell in the KLA, whether it was at the bottom of the organization or at the top of the organization?
It was at the top of the organization. The term GHQ was sometimes used as well, either in English. And I think when we were speaking through interpreters, the interpreters used both phrases, General Staff and GHQ, but I was clear that they both meant the same thing at the top.
So now going back to this OSCE document that we looked at a minute ago from 24 November 1998, where on the second paragraph under item 2, where it says that someone from KDOM had had a meeting with a KLA commander who had received a new directive from the top of the KLA. Do you see that? Oh, I'm so sorry, I'm jumping ahead before the item is on the screen. No, I'm sorry, we were still on the OSCE document. Do you see that there on your screen?
In the second block, yes. I had received a new directive from the top of the KLA. Yes.
And before we move off of this document, were you able to see the date on the KLA General Staff document? We've talked about the date of the OSCE report being 24 November 1998. If we can just go back one last time to the KLA document, which is U002-2851. I'm sorry, that's the last page. It's U002-2849 through U002-2851. In both English, and it's the same ERN in Albanian. If we go to the last page, of that document in both languages. Do you see there on the bottom the date on that document
Yes, I do.
as being 19 November 1998, which is 5 days before 24 November 1998?
Yes.
Do you also see on the left-hand side of your screen, the Albanian version, which is the original, a stamp and a signature?
Yes.
Thank you. Mr. Young, I'd like to draw your attention to to certain events that you talk about in what's now in evidence as P392, and also Exhibit 407, P407, which is your SPO statement and also a 4-page statement that you drafted for the ICTY. And again, I'm not going to ask you to repeat everything that's in that statement. I just want to bring you to a particular part. In that statement, starting at page 15 through page 26, so for quite a number of pages, you describe in detail your knowledge of the abduction of Aimer Jafici. Specifically, you describe that you learned that the abduction happened on the, you learned of the abduction on the day that it happened, 9 March 1999, and that you were at a meeting with KLA officials when you learned of the abduction. You described that you met with several KLA officials at different locations on that day in an effort to locate this man, Aimer Jafici. I want to focus your attention first on a conversation that you had at what you describe as a group of houses near Randabrava. Do you recall that part of your statement?
Yes, I do.
All right. And in that part of your statement, you identify that you ended up meeting with someone named Commander Drini, and that you spoke with Commander Drini about what he knew about this abduction. Can you tell the panel what Commander Drini told you about whether he knew anything about this abduction prior to your bringing it to his attention?
Commander Drini made it very clear to me that, according to him, he had known nothing about the abduction. It had not been done on his orders, but he was making inquiries, and he clearly took the matter very seriously. He had arrived very quickly, along with our regional director, General Maisonneuve, after I had reported my suspicions about who was responsible.
You describe in that same statement that you ended up also meeting with someone named Skender, who you understood to be the commander of the KLA's 124th Brigade. Can you just tell the panel whether or not it was your understanding that he was involved in any way with the Aimer Jafici abduction?
Yes, my conversation with Skender took place before the arrival of Drini. Drini only came as a result of my reporting my conversation with Skender. Skender initially was indicating to me that he, and as far as he was concerned, the KLA were not involved in the disappearance of Mr. Jafici. However, in the course of the conversation, due to something that Skender said, I realized that he must be involved, and that is what led me to report this development to our headquarters in Prizren by radio.
All right, and I want to ask you then, after you spoke with Commander Drini, did you then go to meetings in Terpeza to try to follow up on this abduction?
Yes, I did.
And I want to focus you on your second meeting in Terpeza. And you say in P392 and also P407 that you ended up meeting with someone who was introduced or you believe to be Chelik, and that you later that you came to know that person's identity. Who was Chelik, the Chelik that you met with at Terpeza about this Chafichi abduction?
Chelik was Mr. Fatmir Limai. I already knew that that Chelik was the nickname of Mr. Limai. I had never met him before, but during the meeting, when it became difficult, it was indicated to me by my colleagues that this was Mr. Fatmir Limai, of whom I had heard previously, and that I already knew, as I say, that his nickname was Chelik, Steel.
And in the course of your conversation with Fatmir Limai, did he acknowledge that the KLA had detained this man, Aimer Jafici?
Yes, he did.
How long did your conversation with Fatmir Limai last?
Hard to say, perhaps 15 minutes. It wasn't over in a short time, but it wasn't that extended. Essentially, we weren't reaching an agreement, and it broke up.
And how far away from him were you when you had this conversation?
I was standing quite close to him.
And did you come to an understanding of what level of authority Fatmir Limai was speaking at when he was talking to you about the KLA being in control or having this man in detention?
Yes. One of my points for the meeting was that I was there with the authority of Commander Drini, who wished me to at least have access and to see the detained man. And so therefore, as far as I was concerned, I had the authority of Commander Drini behind me, and I pointed this out to Mr. Limai. Mr. Limai, however, responded that the detained man was out of the responsibility of the zone commander and was under the authority of the general staff.
Your Honor, I ask that we move briefly into private session for my next questions.
I'm sorry, into private session, Madam.
Your Honours, we're in public session.
Witness the defense for Salimi. Mr. Salimi will be asking the cross-examination questions. Mr. Roberts, you have the floor.
Thank you, Your Honour. If you just bear with me for one more second while I just move the monitor. Good afternoon, witness. As the presiding judge has informed you, my name is Jeff Roberts. I'm counsel for Mr. Salimi, and I've got some questions that will go probably through this afternoon and also into tomorrow morning. I know you've been very, very good at waiting for a pause in between questions and answers. Don't know if you've testified before with translation, but obviously if you can continue that so that there is a nice break and no overlap, it makes it much easier for the transcript. Firstly, if I could just go into your background and experience, and obviously you answered questions from the prosecution about this earlier, about your experience, I believe it was in the Territorial Army and then the Reserve in Norway, Cyprus and Germany. And you said you were part-time. How did that function effectively? Was it a certain number of weeks you would be in service over the course of a year, or how did it function?
Yes, it was a combination of weekends and one period of unit deployment of 2 weeks during the year, and training courses. So I did training courses in the various appointments that I held as a mortar officer, as an intelligence officer, as a rifle platoon commander, and then as a combat team commander.
Sorry.
And in addition, we went on what were effectively operational reconnaissances to Germany, to our area of deployment. I should add, though, that the earlier part of my service with a infantry unit, that was, if you like, typically part-time. It was hard work and many days, and obviously had a lot of responsibility, but it was very much part-time. But by the time that I served in the Balkans, whether in Bosnia or in Kosovo, I didn't have another full-time job, and particularly during my time as a liaison officer for an armoured brigade, I spent a lot of time in uniform. It was well paid at the level of lieutenant colonel, and it combined well with other part-time work that I did. So actually I was spending a lot of time in uniform on sometimes some quite relevant work. So it wasn't, by that stage, it wasn't really a sort of, if you like, an amateur occupation.
Okay. And just to be clear, the first time you saw active service, that was the Gulf War, wasn't it?
That's correct.
And how long were you in active service during that conflict?
About 3 months.
About 3 months. And then you moved, and the next service that I think you set out was in 1996, so that was 6 years later in Bosnia. Is that correct?
That's correct.
And how long were you serving in Bosnia in that capacity?
A total of a year.
A total, so the whole of 1996?
No. I went out in about May after initial training, and my appointment changed, and I was promoted in the autumn, and then I finally returned to civilian life the following May. So it was 96 into 1997.
Okay, so May 96 until May 97. So between 91 and 96, you were again back working as a civilian, if I can use that expression, back at home.
Yes, along with quite a lot of military occupations. Yeah.
And in Bosnia, when you were there, I think you were involved in, is this electoral assistance?
Yes. If I take
sorry, short-term international polling officer. Is that right?
that was a different thing. It wasn't. That wasn't military. I was a short-term polling station officer under UK, FCO and OSCE for some elections in Bosnia. But during my time with initially I4 and then S4, I was asked to look after, I was the, if you like, subject matter expert in our headquarters on various subjects, one of which was elections, and I was the G3 operations cell's representative on the security planning for municipal elections that were coming up. But that was simply one task, extended task that I had, an important one, but it wasn't my only one.
Okay, and during that time when you were in Bosnia, obviously the conflict had finished, so there was no active armed force of either side during the time you were there. Is that fair?
There was some sniping, but not. There were no major engagements involving us at that time.
So is it fair to say that you were, before you went to Kosovo, you were never deployed in a situation where there was a non-state armed group operating?
Certainly in Bosnia there were factions, as you know. There were groups which were connected with the state, but had actually been forbidden under the Dayton Agreement. There were, for example, the Bosniak side had some people called Black Swans who were a concern to us. They were ultimately they came under the state, but they were not, as far as we were concerned, they were not a legal or approved group. So it was a little more complex than simply post-conflict.
Okay, but certainly not a non or a potential non-international armed conflict. You hadn't been deployed. That certainly didn't rise to that level in 96 and 97 in Bosnia when you were there.
Yeah, that's correct.
And just to complete this section, I know you're a solicitor. You've never been an expert military witness of any type in any court proceeding, have you?
Not a military witness, no.
No. And obviously haven't published in relation to non-state groups or organisations in relation to these conflicts. I know you have published in relation to, I believe, voting in general elections for armed forces personnel, but in terms of non-state actors in non-international armed conflicts, there's no studies or publications that you have produced?
No, indeed.
Okay. Now, can you just confirm when exactly you did deploy to Kosovo in 1998?
I don't know the exact date. It was, I would say it was in November.
If it helps your statement in confidence, if I can use that terminology, because I think that was yours that you sent to the ICTY, puts it in November 98. I just wondered if you could be any clearer as to when in November, if it's towards the beginning or the end.
Mm-hmm. It wasn't at the end, but I wouldn't like to be more specific than that. And of course, we did have training that preceded that in the United Kingdom.
And just in terms of if one splits the difference then and puts you in the middle of November, the document you were shown earlier dated the 19th of November, I believe, that would be literally just as you arrived.
That may well be right, but I can't confirm it without the exact date of my deployment. I'm sorry.
Understood. And And where, can you explain just where exactly you were based throughout your deployment and whether this changed?
Yes, it did. We initially flew out to Belgrade, where we spent one night and picked up our light armored vehicles. I was one of the drivers of those vehicles. I'd already been trained in it. We then traveled to Prizren in Kosovo, where all of us in my particular party, who were the UK, the new, if you like, UK KDOM party, we were all initially in a base in a hotel in Prizren, from where we went out on a daily basis to what was going to be the area of our coordination centre.
And what was that area of your coordination centre?
It was based in Rahovac, and extending from there north to include Maleševo or Maleševa. It was an area where there had been considerable fighting during the summer of 1998 and was regarded at the time as a very sensitive part of Kosovo. But initially we were patrolling by day and returned by before dark, but that did change fairly quickly.
And I think where you talked about the fighting in summer of 1998, the damage from that fighting and the destruction was still very visible, wasn't it?
Yes,
in Maleševo and Rahovac. Which zone was this located in? Which KLA zone? Do you recall that this area of responsibility was located in?
Zone 3, or also known as the Pastric zone.
And why do you consider that was called Zone 3? Is that what you were informed as the nature of the zone?
Yes.
Or the number of the zone?
Yes, certainly that was my understanding. Probably Pastric was the more usual term, but it was a zone of the KLA.
Yes, if I was to say that it wasn't Zone 3 at all, that would surprise you or not?
I think it probably would surprise me, but I've no difficulty in accepting that, of course.
Do you know which brigades had which KLA brigades had responsibility over your area of responsibility over CC1?
122 and 124 brigades were the ones which I met, but I couldn't say that my knowledge of the brigades ever extended to, in military terms, things like boundaries and so on, which did in any event change or could be flexible. But 122 and 124 brigades were the ones, the numbers I was most familiar with.
Did you travel outside of your area of responsibility during your time?
Yes.
And where did you go?
It was partly when I was a patrol commander based in Maleševa. We had to. Sorry, are you asking about our boundaries or the KLA boundaries?
Sorry, I'm asking about you personally and what your deployment was. So you were deployed in CC1, which covered Rahovac and Maleševo. And that was where the majority, or the vast majority of your work was carried out, wasn't it?
Yes, it was. To qualify that, our CC more than once deployed people to where an incident had been reported. For example, if locals were reporting to us that there had been bodies had been seen at some location, and because we didn't have boundaries like military boundaries, you've got to be very careful if you've got weapons, clearly. You can't go rushing out of your own boundaries. But since we weren't armed, we didn't regard the boundaries as being absolutely laid down and having to be coordinated. So at times, our patrols arrived at incidents outside our own boundaries before the local, before the OSCE headquarters responsible for that area had responded. It's partly because we were there first, we were experienced, we had good lightly armoured vehicles and a lot of experience, and probably were better off for numbers.
But just to be clear, that was only a short distance outside your area of responsibility. You wouldn't be trekking off across the country into northern Kosovo or northeastern Kosovo or anything like that, would you?
I didn't, some of us did.
Right.
We were seconded to other areas.
I'm interested in what you knew and can see and can testify to, obviously. And so just to be clear, you never went to any of the other KLA zones, apart from your obviously very short trips out. But in terms of other trips out to Kosovo, you were not deployed over to those areas.
That's correct. Apart from an extended orientation tour, which we did right at the beginning of our deployment. So we were taken by the then defence attaché, British defence attaché.
This is John Crossland.
Correct. And so I saw a good deal of the rest of the country, particularly in the western part during that period.
And did he give you a briefing about his view on the level of organisation of the KLA at that time when you deployed in October and November?
I don't specifically recall a particular briefing.
Okay, well, we may come back to that tomorrow and to see whether what he has said is consistent with your understanding. But just back to in terms of your patrolling and your assessment, you accept in general terms that any comments you made or any opinion that you have given in your statement about the level of organisation, about the chain of command within the KLA, is pretty strictly limited to your area of responsibility in CC1.
Yes.
And can't go beyond, obviously, the time and dates that you were there. So we're talking 15th of November, give or take, obviously, without a specific date, up until, I believe, the 19th of March was when you left. Was that right?
Yes.
1999, obviously. So I just want to go through some of your opinions, if I can use that term, about the organisation of the KLA within that specific area. Now, in your statement, I can obviously bring it up at any point, but obviously correct me if I'm wrong. I think this is paragraph 118 of your SPO statement, which I'll just get the P number for the record, which is P392. You told the SPO that in your assessment, the KLA were very organised and had reasonable communications, considering the terrain and distances involved. Do you recall telling the SPO that?
I think just taking it perhaps out of context, very organised. I'm not saying I didn't use that phrase, but the organisation clearly was not comparable with, for example, a modern army in possession of its own territory. Clearly, this was all in the context of a military organisation which was, for one thing, was developing and indeed changing. But it wasn't, for example, simply a series of village militias that didn't connect with each other.
Yes, I think that's what I'm trying to get to, is to understand exactly what you meant in your statement. And obviously, phrases such as that can have different meanings depending on the context. You're talking about there being a level of organisation. At that point, And we're talking in February, March 1999, is that correct, when you're making this assessment?
Well, that's the point at which it would be the most developed. I think at the time of, for example, the kidnapping of Mr. Gafici, it was as developed as I saw it by then. And I would hesitate to say that that was the same when we first arrived. And indeed, if it had been the same when we first arrived, I'm not the witness that can say that, because I personally didn't make that observation.
Okay. And just to follow on other comments that you made in the context of your statement, you stated that the KLA, this is paragraph 20, didn't use badges of rank, but you were clear that they had a hierarchical command system, even without any outward signs of ranks.
Yes.
And what's your basis for that?
My observations of particular commanders who I met, and the fact that that soldiers carried out their orders, and that was very visible and indeed very respected. It was something which naturally I would notice was important to us. It was a disciplined organization of people very, very dedicated to their own people and to the future of their part of the world.
Yes, I think that the dedication was not to be doubted. I think the question is obviously in terms of how organized and what chains of command were in operation. And talking about, I think you're talking about your observations of particular commanders. In your statement, you originally said that you were sure you'd met Drini, Commander Drini twice. And then I believe in your preparation note, you corrected that and said actually it was only the one time. Is that correct? Sorry.
Yes, that's correct. I think looking at the my messages which have been produced to me by the prosecution, I can see that I initially referred to meeting Drini twice, and then at some point became aware, no, that wasn't quite working out, and I made a number of attempts to try to make sense of it. But I'm quite clear in what the actuality is, that I met Drini on the day of...
On the 9th of March.
On the 9th of March. And I have the clearest possible recollection of that. Not only that, there's there are the notes in my notebook, but also the note which I gave to General Maisonneuve, which I understand he produced for the ICTY, and that was a contemporaneous note. So, and in fact, I have the very clearest recollection of everything in my conversation with Drini, which was in English. So that part of it is very, very clear. Did I meet him some other time? And I've reached the conclusion that I thought I might have met him on the day of the mortaring of Zocester, and I didn't. I met a different commander, which was Skender, the brigade commander rather than the division commander. And the reason that Drini had been large in my memory of that day was that the mortaring was carried out on his orders, and everyone was very clear about that. The KLA, speaking to me, was clear. It's Drini who's ordered this, and indeed Drini had given that indication himself. That indication had been given to the Serbian side, because I then carried out a dump. Yeah.
Cut you off. I just trying to get through these questions as quickly as we can. Sure. But just to be clear, so you accept that you were mistaken in your earlier statements and that you believed you had seen him and that you hadn't? Twice, sorry. You'd seen him twice or met him twice, and that was wrong.
That's correct, and I have corrected that in my...
In your preparation note, yes. But this was obviously the only time you met Drini, obviously the one time. Did you meet anyone else from the Pastric Zone Command that you're aware of during your time in CC1?
Well, what level of command? Of course, I met people from that organisation, but what are you asking about? A particular level
I'm
of
talking
command?
about the staff of the
Staff.
Pastric Zone Command. Sorry, thank you for the indication. I should have been more specific.
There's nobody I can think of other than their liaison person with OSCE. They had a particular man mentioned in my statement who was the nominated liaison with KVM and was part of that or came under that headquarters.
Yes, so your interactions with the KLA and the zone staff were filtered. There was an intermediary, wasn't there, effectively, this liaison officer that you met and were meeting on the morning of the 9th of March, I believe, as well.
Yes.
But so you didn't have direct contact with the zone command staff is what I'm trying to get to.
That's correct.
And I think in your interview, you even stated that you didn't have a detailed knowledge of the KLA brigade structure and locations within the Pastric zone. That's paragraph 19 of your statement to the SBO. And that's fair, isn't it? You didn't have a detailed knowledge then, and nor do you obviously have it now of what the structure of the brigades or where they were located.
That's correct.
Just talking about the top of the organisation, or what you've referred, I believe, as the general staff. Now, you're very clear in your statement that you don't know when the general staff was established. I'll just read that out very clearly. That's paragraph 122. Yes, very clearly. I do not know when the KLA General or GHQ was established. That's correct, isn't it?
That's correct.
And you then proceed to say that for various reasons, CC1 did not seek to engage with KLA GHQ, nor was it practicable to do so. Do you recall saying that, and is that still correct? Just yes or no for now would probably be of assistance, and then I'll ask some follow-up questions.
Yes, I'd rather you did follow up, but yes, that is the position.
That is the situation that you didn't know when they were established, and you did not seek to engage with them. Your Honours, I note the time. I think I'm just about to move into a new area, so if it's convenient, I'll stop there. Thank you, witness. We'll resume tomorrow morning.
Thank you for being with us today. We will start at 9 tomorrow. And remember the warning I gave you not to speak about the case outside of the courtroom and to let us know if anyone tries to contact you. The usher will escort you out. Mr. Ellis.
Your Honour, if there's a convenient moment, either now or tomorrow morning, there's one discrete matter on which I'd wish to address the panel, to ask for a short extension for our response to filing 1764.
Hold off just a second. I had unplugged my microphone already. Go ahead.
Your Honour, there's one short matter I'd wish to address the panel on either now or tomorrow morning, and it was to ask for a short extension for our response to filing 1764. Which was the prosecution's filing, a Rule 107 filing in relation to 2 witnesses.
How much time do you need?
Very short, Your Honour.
Well, tell me.
Your Honour, it's simply, and I should have made this earlier, but we've been a little busy with preparation for the witnesses this week. The filing's due tomorrow, I think, in terms of our response. And I'd just seek a short extension until perhaps Monday next week.
Any objection?
No objection.
Okay, granted.
Thank you, Your Honour.
Your Honour, may I just raise at this stage 2 issues? First of all, the public-private divide as regards the legal argument that occurred earlier today. I think it must have been a collective oversight by all of us in court. but that legal argument took place in private session. And clearly there was nothing in the legal argument which justifies private session, because there was nothing in it which was potentially identifiable. So may I ask for an order now or tomorrow morning releasing that legal argument into public session so that the transcript can be released and the video, if necessary, released. That's the first thing. The second thing is, despite taking stock earlier in these proceedings of the extent to which things have been done in private session and public session, and the refrain that I think all of us have joined in with, that we can always review the transcript afterwards and then release it, nothing to my knowledge has been done to advance that objective at any time. And so at an appropriate moment, I'm going to invite Your Honour to lay a timetable for the parties to respond to, because we are now many months into the trial, and there's a vast amount of material that should already have been released into the public domain in the form of redacted transcripts. And we can't allow this to continue, collectively allow it to continue, because obviously there are concerns, as we are all well aware, about the degree to which the trial takes place in public. On the first issue, it seems to me, subject to anything anybody else might have to say, there's simply no argument to be had about it. In relation to the legal argument on the last witness's evidence. And in relation to the more general issue, which is also extremely important, I think we're all collectively to blame, perhaps, for not implementing the system we've all promised to implement, which is to make sure that each witness, when they're finished, there is a process for working out what is truly identifying, and the rest of it be released into the public record.
We will look into it. First of all, do you wish to respond?
Very briefly, if we did do the argument in private session, again, I don't have a recollection of anything confidential, but since it was private, if we could just have the night to make sure there's nothing in there. I take my colleague at his word, but we'd just like to look at it, and then if there's nothing private, we have absolutely no objection. As to the latter, again, we're happy to work inter parties to come up with a proposed timetable. We have actually undergone this procedure because I personally was involved in a witness that I put on, so we have done that for one witness, and we certainly can
I'd certainly
undertake
like
some-
to start this at inter-party discussions, if you could do that.
Yes, I'm not quite sure how it's fallen through the cracks, because I don't think any transcripts have actually been released into the public record, or have they? Oh, they have.
Maybe we're going to be...
We'll start inter partes, with, perhaps with counsel in court today.
We're going to have a week now after this where we're not in the courtroom every day, and perhaps by the end of next week, you can come up with some sort of a plan and present it the Monday that we reconvene.
Thank you very much.
And if everybody would look at the overnight, the reviews of the argument, and then we'll take whatever action we can deal with. Mr. Roberts, did you have something?
Two things, Your Honour. One, I might be slightly longer tomorrow morning, but not substantially more than what I'd said already. But secondly, just the extension sought by Mr. Ellis and granted by the panel, I assume applies to all defence teams. I just wanted it to be clear on the record that that's the case.
Barring some objection, yes, it is
Much
extended to all the defence teams.
Thank you.
Anything else?
No, Your Honour.
All right. We are adjourned until tomorrow at 9.
All rise.